Okay, there we go. Now you should be able to hear me, I think. Maybe. Can you hear me now? The reason we're doing these pre-trial hearings live like this is to figure out what to do when the real thing comes here. Okay, there we go. Now I'm talking. Wow, I was talking that whole time. You guys couldn't hear me. So, what I was saying is the judge is making a great point. He's like, look, how are these people supposed to be prepared? She's saying, well, let's give them another day. What do you mean, give them more time? We're 11 days from seating the jury. We are 11 days from seating the jury. And the judge is asking her, Shanna, thank you for letting me know. So the judge is like, look, realistically, we're not going to have 700 witnesses. I tried to do some math when you guys couldn't hear me, and sorry about that. So 700 witnesses, that's 700 direct examinations. The judge said there are 6 defendants left. So 700 times 6 is 4,200. That means there would be 700 direct examinations and 4,200 cross-examinations, which means by the time this trial is over, the entire jail sentence would have been out. I mean, it would take 30 years. It's unbelievable that they have 700. And over half of those are professional witnesses. That means paid. These are our tax dollars. These are our we're not in Georgia. I'm not in Georgia. If you're in Georgia, I'd be lit if I was you. But this is how the government is using our tax dollars, right? To put 700 witnesses that are never going to testify. It's crazy. And obviously the judge is like, I mean, he's having a hard time. I can tell he agrees with the defense. They should have the time to prepare. They should have the witness list. He's also concerned about how are we going to have jury hear 700 plus witnesses. And then he goes to the prosecution and says, why don't you narrow it down? And they're like, we can't? I mean, they're just so dense. So dense. Yes, you can. You don't need all 700 witnesses. In my mind, if you can't prove your case with under 100 witnesses, you don't have a case. I mean, come on. Like, I've never had a trial with more than 10 witnesses. I have never needed more than 10 witnesses to prove my point. And I just feel like if you need 700 plus witnesses, you're scraping, like you're really clawing for something. And you could see Mr. Steele was like this. He's so over this. Okay, here we go. Okay.
Like I said earlier, the court's had an opportunity to take a look at the defendant's motion for remedies based upon the motion to strike, motion for remedies, state's response,
Come on, Judge, come on. I feel bad for Mr. Steele. He's probably on the edge of his seat right now. Come on, Judge. Make that ruling. Let's hear it. I want him to hurry because I have a 3 o'clock appointment.
motions in limine from 26 to 32.
A motion in limine is any pre-trial motion, anything that's heard right before the trial. Just like this is a motion to exclude witnesses, and that is a motion in limine. That's a pre-trial motion. It's something that's heard before the trial goes on.
Persons as affected on this indictment. The court's also considered, for the purposes of ruling, states 1 through 7, defense 1 through 4, and court 1. As well as the court's historical reflection on the trial of this case since it was indicted and re-indicted in those sessions of court. I do understand, Mr. Steele in particular, that this particular discovery has not come out in a method and manner that it might have been a smoother way to kind of let it go, to proceed, I should say. I do find that looking at news and the other trilogy of cases that you have cited for the court's edification, that
Come on.
that under OCJ 1716.3, a copy of the indictment accusation list of witnesses furnished.
Come on, Judge.
I'm also considered 17-16-4, which is disclosure of evidence by the prosecution and the defendants. Prosecuting attorney shall no later than 10 days prior to trial, or as time as the court orders, disclose to the defendant, make available for inspection, copying, and photographing any relevant written or recorded statements by the defendant or copies thereof within the possession, custody, and control of the state or prosecution, any portion of any written record containing the substance of any relevant oral statement made by the defendant, whether before or after arrest, in response to interrogation by any person then known to the defendant to be law enforcement or member of the prosecuting attorney's staff.
Blah, blah, blah. Hurry up.
Then 2 also says you should stay shown no later than 10 days prior to trial, or otherwise ordered by the court.
I just
Furnish
lost
the
my
defendant a
chat.
copy of the defendant's Georgia Crime Information Center criminal history. Then 1716.4 also talks about books, papers, other tangible objects
Oh my gosh, hurry up.
that are in custody, in the possession, custody, and control of the state or the prosecution, are intended for use by the prosecuting attorney as evidence in the prosecution's case in chief or rebuttal at the time at the trial of any violation of Part 2, Article 3, Chapter 12, Title 16. Such evidence shall be made 10 days prior to trial. And it basically just covers in 16.
Oh my gosh, come on, hurry up.
1716.4 the requirements of disclosure of evidence. I've also considered 1716.8, which is the list of names and information concerning witnesses and about the state's requirement.
Y'all, if I were the attorney in the courtroom, this
would
would I'd be tapping my foot.
Compliance with the prosecuting attorney.
Let's get to the
Filing for
ruling.
trial shall furnish to the opposing counsel as officer of the court in confidence the names and addresses, current locations, dates of birth, telephone numbers of that party's witnesses, unless for good
We know.
cause the
We
judge
already read the
allows
code,
exception
sir.
to this requirement, in which the event counsel shall be afforded an opportunity to interview such witnesses prior to the witnesses being called to testify. And then 1716.6 says that gives the court what to do in terms of failure to comply with discovery requirements. And as with many of the cases to include, the court has considered to include news. It's been cited earlier. At 316 Georgia 639. If at any time during the course of proceedings brought to the attention of the court, the state has failed to comply with the requirements of this article, the court may order the state to permit discovery or inspection, interview of a person, grant a continuance, or upon showing of prejudice and bad faith, prohibit the state from introducing the evidence not disclosed. Or
Okay.
presenting the witnesses
So the
not
reason he was claiming
disclosed,
bad
or
faith
may
is because
as
it
such
has to be bad faith in
other
order to
orders
get
and
excluded.
adjust under the circumstances. And then it gives a reciprocal issue if the defendant doesn't disclose or fails to comply with the requirements of this article. The defense has it, so it's the same as being reciprocal discovery. The responsibilities are the same. I know that the statute 1716.8 says 10 days before trial. I know we've commenced trial, and we commenced trial in January, but we have had a long and very arduous jury selection process, and we actually, even though we've commenced trial, we joined issue back in January the 4th of this year, we still have, we're gonna, the jury will then be asked to hear this matter. So ordinarily, while I'm reading what the requirement of 17-16-8 and the other statutes read together comply with,
I know, Shannon, this
there is a
judge.
continuing requirement for those particular statutes to continue to be adhered to. I have some concerns about how the materials has been meted out in this case. That bothers me because, being an advocate, you do need to get ready for trial.
Y'all.
But I don't, and looking at the
If I was
case
in the
law,
courtroom, I would be dying right now. Tell us the answer. What is your decision, sir? This judge reminds me of several judges in Dallas County. Just so you know, there are several judges like this in Dallas County that will delay before they make a decision. Of course, most of their stuff isn't like this public. Come on. I feel like a quarter of a lawyer's job is just staring at the judge while he does his job. Like when we're in the courtroom.
and looking at 17
Oh wow, more code.
8, those requirements are set forth to prevent a defendant from being surprised at trial by a witness or to include evidence that when defendants have not had an opportunity to review or interview. So, I'm supposed to look at,
But not that I'm supposed to look at. And then I looked at.
if they haven't been run already, because that is something that at this point in time, there is no way that defendants can go ahead and avail themselves of the statutory procedure that's set forth. So that's the other fashion that the court's going to make sure that is adhered to. I'm only in order for lay witnesses unless you tell me that there is a professional witness for good cause that I need to run, or I need to require that be run. But for any lay witness going to testify, it is my expectation that the state will provide that. Is that?
Your Honor?
Yes, ma'am.
As it relates to the witnesses, as I had spoken with the court before, we did speak with the GBI and the Georgia Crime Information Center, and they told us back when we first brought this issue up that the defendant could have had his GCICs in 2 days, given the time that they had then, that the state is literally not that we don't have to, we literally are not allowed to. I received that from the counsel. Mr. Steele stated he knew him personally, so I reached out to him personally, to the legal counsel for the Georgia Bureau of Investigation, and one of the requirements of the state maintaining its certification is that we not do exactly that. And what they told me is that all that the defendant has to do is ask the court, and the court issues an order, and they get those witnesses in 2 days from the Georgia.
However it happens, I don't mind how we do it.
Okay.
But I want it to happen. So, Mr. Steele and Ms. Love, if you all want to do an order for my signature, I will go ahead and get that done. But I need to know the universal lay witnesses that you all want, because there may be some you just don't want to have with it. GCIC 1 4. I mean, I'm not saying you should. I'll order all of them, but if you don't, if there are witnesses that really don't need to, there's no reason to run their criminal history, I would just say you exercise on the
How
side of
ridiculous.
caution. But I will prepare an order such that they can get the,
This is awful.
those criminal histories.
So far, every ruling this judge has made, every single ruling I've watched this judge made, every single one has been for the state, always to the benefit of the state. I can't believe. So he said, I'm going to let these witnesses in as long as you do a criminal background check and send it to the defense. How is the defense going to know what that person's testifying about with just a personal It's ridiculous. A criminal background check is insufficient. And this judge is always erring on the side of favoring the prosecution. And that's probably because, they all have their paycheck paid from the same location. They work for the same government, right? It's just exhausting. And the bias.
They said at the time I told them the number of witnesses, and they still told me that day, that number.
Let's see what this kid says.
Absolutely, being the determination of whether or not it's a citizen, the persons are citizens for purposes of then application.
So Shanna, how long is the trial gonna take? It depends on how many witnesses they have. Like, they're trying to do 700, and 250 of them are lay people, so they have to go do background checks for all the 250 lay witnesses and hand them over to the defense. And yes, the government is gonna pay for that. If I was a taxpayer in Atlanta, in Georgia, I would be lit right now. Like, this is ridiculous. I don't know how much longer today is going to go. Unfortunately, I can't continue to stream because I have a 3 o'clock appointment that I am now late for. Thank you for being here with me.
As follows.
I mean, this is just, this whole trial, yes, Shanna, it is going to last till 2063. I swear to you, I will be retired. I will be retired by the time this trial is over, as much as this prosecution. This judge will have retired. Like, 3 new judges will have come. There will be elections and new judges will come. And oh my goodness, what a mess. What an absolute mess. And it just shows our government can do this. Our government has the ability to just come in and sweep things up, and it's awful. All right, y'all, thanks for joining me again this afternoon. Make sure you hit like and subscribe, and I'll be back tomorrow if there's anything going on, and certainly Monday when there is something going on.